in the issue in this case is whether or not CIR is correct in assailing PHILEX Mining's refund. Di ba sabi ni CIR na the PHILEX Mining failed to comply, failed to submit the subsidiary sales and subsidiary journals. Subsidiary journals failed daw. Then sabi nga ng CIR is, sabi ng Supreme Court is CIR is not correct. Sa language, the language in section 110 is plain, clear, and unambiguous. Para magkaroon ng, in order to be creditable, the input taxes must be evidenced by validly issued invoices and OR containing the information enumerated under section 113 and 237. Yun lang. The section 110 is very clear na wala dun, hindi nakalagay na kailangan pa mag-submit ng subsidiary journals. The law does not require subsidiary journals. And also, failure to maintain the subsidiary sales and purchase journals does not automatically outright the denial of its claim for refund or credit of unutilized input VAT. These are not part of the requirements for PHILEX Mining to be entitled thereto. Section 112A of the tax code is very clear. Clear talaga. No construction or interpretation is needed. The court may construe or the court may not construe a statute that is free from doubt. Kapag wala namang doubt, then why interpret? Diba? The court may not construe a statute that is free from doubt. Neither can we impose conditions or limitations when none is provided for. Kapag walang nakasaad dun, walang nakalagay na condition, then why construe? There is no need for a interpretation. While tax refunds are in the nature of tax exemptions, strictly against the tax refunds are in the nature of tax exemptions and are construed strictissimi juris against the taxpayer. So, tax refund laws are strictly construed against the taxpayer. Siyempre, kasi kapag tax refund, that is equal to a tax exemption. So, strictly construed against the taxpayer. Tax statutes shall be construed strictly against the taxing authority kapag tax statute. Verily, the CTA did not err. The CTA did not err in ruling that the absence of subsidiary sales journal, subsidiary purchase journal, and monthly VAT declarations is not sufficient to deprive PHILEX Mining of its right to a refund. So that is, the CTA is correct. The Court of Tax Appeal is correct wherein it is not anymore necessary to maintain a subsidiary sales journal it is not a requirement to have the subsidiary sales journal, subsidiary purchase journal, and monthly VAT declaration. It's not anymore necessary. But and also the failure to maintain those records is not an outright denial of their claim for refund. So this case, the case of CIR versus PHILEX Mining is also compared to other cases. So these are important notes also. In case of Western Mindanao Power Corporation, the CTA denied the taxpayer's claim for refund because the taxpayer's OR do not contain word zero rated. Kailangan, in sustaining the CTA, the Supreme Court ruled that the failure to print the phrase zero rated on the VAT OR was fatal to the claim for refund of input VAT on zero rated sales. In order for a taxpayer to claim for a refund on the ground of zero rated sales, dapat yung OR nila merong nakaprint dun, may nakaprint na zero rated. Now, there is a phrase, there must be a phrase which includes zero rated. Dapat may zero rated sa VAT OR nila. Kasi in the absence of that, otherwise, it would be fatal to the claim for refund of input VAT on zero rated sales. In the case of Bonifacio Water Corporation versus CIR, the taxpayer indicated in its of OR a name not approved by Securities and Exchange Commission, the SEC. The court ruled that the absence of OR official receipts issued in a name approved and authorized by the SEC was tantamount to non-compliance with the substantiation requirements under the law. So, sa case kasi ng Bonifacio Water Corporation, then there was a name. May nakalagay na name and not approved by the SEC. So, that absence of that name in the OR is tantamount to non-compliance. Thus, from the foregoing, it is clear that the petitioner must show satisfaction of all documentary and evidentiary requirements before an administrative claim for refund or tax credit will be granted. Perforce, the taxpayer claiming the refund must comply with the invoicing and accounting requirements mandated by the tax code, as well as the revenue regulations implementing them. So again, sa case ng Bonifacio Water Corporation versus CIR, nakalagay dun yung pangalan, pero yung pangalan na yun, hindi naman yun recognized or approved by the Securities and Exchange Commission. So from that act, there was non-compliance. So therefore, it will hinder the taxpayer to claim for a tax refund. So that is the case of CIR versus PHILEX Mining, wherein it is not anymore necessary to maintain or to have or to submit the subsidiary sales and purchase journals in order to claim for creditable input tax based from a zero rated sales.